Welcome to the NAIFA webinar series, providing you with timely information and training each month on topics of interest. This is Brendan Burnett, Director, Professional Development and Education Programs. This month we are presenting Budget Bill Changes to Social Security, What Advisors Need to Know. With me today are Mark Kenner and Jim Blair. Mark is currently part owner and president with Premier Social Security Consulting. He is also a certified instructor for the National Social Security Advisor Program. Mark created and developed the National Social Security Advisor Certification Program with his partner Jim Blair. Additionally, Mark has over 30 years of experience in public accounting. Jim Blair is currently part owner and Social Security consultant with Premier Social Security Consulting. He is also a certified instructor for the National Social Security Advisor Program. Jim retired after 35 years with the Social Security Administration. And Jim created and developed the National Social Security Advisor Program, certification program, along with Mark Kenner. So today, Mark and Jim will explain the recent significant changes that have been made to Social Security and the remaining strategies that are available to you and your clients. And the recent Social Security changes do include changes to restricted application and file and suspend. There's also Medicare changes and Social Security disability insurance changes. And all of those will be discussed today. And our presenters will also provide the effective dates of the changes. During the presentation and question and answer session, you may type questions in the question box on the right side of your screen. However, questions will be answered at the end during the question and answer session. So let's begin. Mark, welcome to the webinar.
Thank you so much, Brendan. Thank you so much for having us. We appreciate the opportunity to address and educate NAIFA members about the changes to Social Security. You know, Social Security changes don't happen every day. Once a year we see COLA adjustments, increase in FICA wages, what it takes to obtain a credit for retirement income benefits. But now we've seen a wholesale or a slew of changes that were signed into law by President Obama on November 2nd, 2015. So believe me, I've had more excitement over the last month or so than I envisioned I'd have with educating advisors on Social Security. My name is Mark Kenner. Like Brendan indicated, I'm a 35-year CPA, been practicing in Cincinnati for about that long time period. In 2010, I joined forces with Jim Blair. Jim's a 35-year veteran of the Social Security Administration. And together, we do two things. We do one-on-one consultations with folks, and we also educate advisors nationwide. Jim, welcome to the webinar.
Thanks. It's good to be here. Pay no attention to my voice. It's a little hoarse today. The doctor said I'm not contagious, so Mark doesn't have to worry. The rest of you guys being on the other end of the phone, you don't have to worry either. But I guess it sounds a little funny.
Well, I'm heading to Louisville after we're done, Jim, so I won't catch what you have, I hope. Anyway, Jim, let's talk about the budget bill. This was passed by President Obama November 2nd, 2015. And it's called the Bipartisan Budget Act. Included in this Budget Act is Section 831. And so let's look at the title, Closure of Unintended Loopholes. So that tells you right there what Congress was thinking when they made changes. We're thinking about making changes to the Social Security program. And Section 831 is changing the file and suspend and the restricted application strategies. Basically, Jim, it's affecting the second leg in our three-legged stool, which is coordinating spousal benefits. Pretty big changes, would you not agree?
Yeah, they're pretty major changes for a lot of folks. It doesn't take away all their options, but it certainly takes away a couple of the top ones that they had in a lot of cases. So we're going to look at the impact of those changes on who it affects, who it doesn't. We'll still look at these for a while. And we'll talk some more about that as well. But it's definitely going to have an impact on people's decision on when to take their Social Security benefits. But it's still important for people to remember that they need to coordinate with their spouse while it's an individual benefit, a couple can still coordinate their benefit.
Jim, rumor has it that you were in the background when President Roosevelt signed the law back in 1935. So since then, Jim, when was the last major change you saw in the Social Security program?
Well, the last major change was in the mid 80s when President Roosevelt signed the law. I don't think I was there. I think it was in the bathroom or something. But the last major change was in the early 80s. We saw a lot of changes, and those changes affected on this phone call. But what it didn't do in a lot of cases was affect people who were either receiving benefits or close to receiving benefits. These changes came pretty close to doing that. We've had a couple of other changes in the last 5 years or so that also affected people, not quite to the extent this did. So it's got me a little worried we're starting to see, but I think they recognized even when they passed this law, because originally it was going to be just as soon as it was signed, wham, bam, it's done, you're done, taking away benefits. So they made some changes to that, and there's a little hope there.
But Jim, the changes that we're seeing now is not really affecting the solvency of the Social Security Trust Fund. Yes, according to the 2015 Trustees Report, the Social Security Trust Fund was going to be depleted by 2034, at which time folks will see a 21% haircut in the benefits. What impact do you know of that these changes will have on moving forward or backward the time of depletion of that trust fund?
Yeah, I haven't seen any talk about it moving it at all, and with the small amount of change that really is affected, I don't see where this has really taken any step at all to make the program more solvent. I guess it goes along the lines of it doesn't hurt the solvency of it, certainly, but as far as it helping it, not really.
Yeah, just to give you some idea what some of the future changes may be. Maybe increasing the full retirement age from the current level of 67 to 70. But it could take 30 years to do that. Maybe taxing more of your wages. Right now, 118.5 is subject to tax. Maybe, Jim, that might become unlimited down the road. Not only will Congress collect more tax, but they may not give you an increase in your benefit amount. Also, tinkering a little bit with delayed retirement credits. So, they got the low-hanging fruit, Jim. There's definitely more they can do to make the system more solvent. But that will take time. It's not going to happen during an election cycle.
No, and it's definitely going to require them to roll up their sleeves and get to work. This one, as you said, was easy, the low-hanging fruit. It's not so easy from this point forward.
So, Jim, address their restrictions now, or to the restricted application.
Well, what they did was they changed the definition of deemed filing. And what deemed filing was before the change is it was a part of the law that said if you are under your full retirement age, when you file for Social Security benefits, the months that you elect those benefits to begin, any other benefit that you're eligible for in that month, you must take that. And what that means is that you file for Social Security effective with January of 2016, you're eligible for retirement benefits, you must take those retirement benefits first. Then if there's a spousal benefit boost that you're eligible for because your spouse is applying at the same time or they're already receiving, then you must take that spousal benefit. You do not have a choice. So deeming pretty much says that when you apply for Social Security, you're going to take everything that you're eligible for. Well, under the old law, the deeming really applied only to your first month of eligibility. After that, you had some choices. What they've done is they, first of all, extended it from full retirement age to 70. So deemed filing now affects people from age 62 to age 70, and they've also changed the terminology a little bit so that it doesn't matter when you become eligible for that additional benefit, you must take it. Somebody applies for retirement benefits in January, in next June, their spouse applies for benefits and now they could get a spousal benefit boost, well, they have to take that spousal benefit boost. So they don't have the option of waiting if they wanted to.
So, Jim, before the new law, deed filing ended at full retirement age.
Right.
So for folks born between 1943 and 1954, the full retirement age was 66. So at that point, at age 66, you can actually elect through a restricted application to claim only a spousal benefit, even though your benefit might be higher. Now, deed filing occurs anywhere between age 62 and age 70. So once you file, you will get paid the higher of any benefit you're eligible for. Am I right on that?
Yeah, you're right. Deemed filing eliminates the ability to restrict your application to just a specific benefit.
Okay, let's talk about file and suspend. File and suspend is now being changed because now for spousal and children benefits to be payable, the wage earner needs to be receiving benefits. As a result, a wife and or a child is not eligible to receive a benefit off of the other spouse unless the other spouse is receiving benefits. Benefits aren't payable if the other spouse decides to file and suspend. So in a normal situation, we would have the wife wanting to collect off the husband of either the husband's spousal boost or half of the husband's benefit. And under the old law, the husband could file and suspend. But now under the new law, that's not the case. The husband needs to have turned on his benefits. So a really big question going forward will be, does the husband turn on his benefits at age 66? Does he wait to age 70? Whereby if he waits to age 70, now his benefit has gone up 32%. And at that point, we're maximizing the benefit to his wife after his passing. And we'll talk more about some common strategies later. Additionally, the cash reserve now is eliminated. And I don't know if the audience understands what the cash reserve is, but if I would have, under old law, if I had filed and suspended at age 66, then I would be starting to build a cash reserve. And if maybe a couple of years later, maybe I'm age 68 now, I need some money to buy a new car, maybe some medical expenses, I can call Social Security and they'll send me a check for all benefits not paid to me. So if my benefits were $2,000 a month and I'm now age 68, they would send me a nice check for $48,000. So that's what we call building a cash reserve. If under prior law, if you did not do the file and suspend, and you went to apply, and you're over full retirement age, they could take you back 6 months. But if you did the file and suspend, they can take you back to the earlier date of either during the file and suspend or the full retirement age. So, Jim, the file and suspend strategy was nice because under this during the suspension mode, a spouse can collect the spousal benefit off their spouse, and you can build that cash reserve. But now that opportunity is gone.
Yeah, it's gone away. You don't have that ability to do that. So really, unless you're going to take your benefit, there's really no need to apply for Social Security.
Jim, would like to talk about the effective dates?
Yeah, those are confusing a lot of people, and they are different. If someone wants to file the restricted application, if they turn 62 before the end of this year, which technically means if their birthday is January 1st of 1954 or before, they will turn 62 in 2015. I know that sounds a little funny to some of you, but you attain the age of your birthday the day before your birthday. So if you're going to be 62 January 1st of 2016, you technically turn 62 according to Social Security December 31st. Therefore, you're in 2015. Those folks still can use the restricted application. It's people that turn 62 next year that no longer have this option. So we're still going to see people taking advantage of this, definitely up for 4 more years, but even longer, because not everybody's going to be able to take advantage of the restricted application right at age 66. So, off and on, it'll get less and less as we get closer, but really over the next 8 years, we're going to see people taking advantage of restricted applications. So anybody that turns 62 this year or before still has the restricted application as a strategy that's available to them.
Jim, a question we get all the time is this. My wife is turning 62 this year, so according to the effective date, she can file a restricted application when she turns full retirement age. Could be 4 years down the road. The question, though, is what does the wife need to do now to preserve the opportunity to file a restricted application in 4 or maybe 8 years?
Well, if it's my wife, I'm going to tell her she's got to go to work, but that probably wouldn't work either. But now she really doesn't need to do anything, or he. It doesn't matter. The spousal benefits are gender neutral, but you don't need to do anything. You don't have to tell Social Security, I'm going to wait until you are ready to begin your benefits or start something. You don't have to tell Social Security anything.
Great. Okay, let's talk about the effective date for filing Suspend. So, according to the new law, if you're going to turn your full retirement age by May 1st of 2016, then you can go ahead and actually file and suspend to preserve the following Social Security benefits: the buildup of a cash reserve, and also to allow the payment of spousal and or children benefits while your benefits have been suspended. So if you turn full retirement age on May 1st, then in the eyes of Social Security, you actually turn 66 or your full retirement age on April 30th. And that gives you the opportunity to file and suspend your benefits by April 30th, 2016. So if you're within that window, more or less turning age 66 by May 1st of 2016, then you have the opportunity to file and suspend to build up that cash reserve and also to allow the payment of spousal and or children benefits while your benefits have been suspended. If you're going to turn age 66 on May 15th of 2016, all bets are off, and you cannot file and suspend. It's a pretty definite date. Not only is the age 62 date definite for the restricted application, but having the opportunity to file and suspend by April 30th, that's also a very definite date. Spouse and children currently receiving benefits due to the wage earner filing and suspending will continue to receive benefits. I call that, Jim, a small miracle. And that's because, according to the original law, that was not possible. The benefits to the spouse and kids would go away 6 months after the bill's passing. But somebody in Congress, Jim, has a heart. I have no idea who it is.
Or they claim and suspend it and have some kids. Maybe that's more like it. They figure, hey, wait a minute.
That's a good one, Jim. The laws that originally was written was that those benefits would go away 6 months after the bill's passing. But somebody caught that. Some congressperson with a heart caught it. So now folks currently receiving benefits while the wage earner is in the suspension mode will continue to receive those benefits. It's a good one, Jim. I like your way of thinking.
I know what happens. Somebody's wife called him and said, my sister and her husband are going to be moving in with us because you're cutting off their benefits. And he said, oh, no, we're fixing that.
All right, there are 3 sets of rules here. If you're going to turn 66 by May 1st of 2016, you have the opportunity to file and suspend. And it's a very hard cutoff date. If you're going to turn 66 on any other date beyond May 1st of 2016, the file and suspend strategy is not available to you. More or less over the next 4 years, you'll also have the opportunity to file a restricted application. And that's if you're going to turn 62 by the end of this year. Like Jim indicated, though, the restricted application filings could be going on for the next 8 years, but with each passing year after full retirement age, the number of folks filing the restricted, Jim, I assume, would just kind of dwindle.
Yeah, we'll see it less and less.
Less and less.
Yeah.
And then, of course, if you're too young and you're not going to be 62 by the end of this year, then you don't have any of these strategies available to you anymore. Restricted application and the claim and suspend is gone. Jim, I've been getting so many phone calls lately. We've got the husband 65, the wife 55. So the fact she's 55 means she can't take advantage of the restricted application or the claim and suspend. She's not old enough. Husband can be doing something, but with such a young wife in that point, no benefit could be obtained by either one of those options. Jim, why don't we start talking about some strategies? You want to start off?
Yeah, the folks who that are going to be 66 by the end of April, or that are 6 and haven't done so, they can file and suspend by April 30th and preserve that their benefits under the old rules. So they would have the money available to them to that look back, the cash reserve available. Their wife and children, or their husband and children, could continue to draw their benefits, or even start those benefits if it's between now and April 30th. But they come in under the old law. So those folks we would want to look at. And you got to keep in mind, too, a couple of things. One, if the person is going to be 66, say, in February, but their spouse is age 62 or 63 or 4 or 5, they're not yet full retirement age, then technically, if they wanted to, they could wait. In the past, they could have waited to claim and suspend until their spouse filed, and everybody just does it all at one time. But now, because of this cutoff, if they wait till after May, even if they were already 66, they're going to fall under the new law. So they need to go ahead and file and suspend to establish that record so that their spouse can come in and do the restricted application later. On the other hand, it could be if their spouse is 62 or 3 or 4 and says, you know what, I'm going to take my benefits anyway, then maybe they don't want to file and suspend. They may just want to do the restricted application themselves. So we still have to look at all the options that are available, but they probably at least want to look at and make sure, should I file and suspend? If I'm going to need to do that, I need to do it before May 1st.
Jim, it just dawned on me. We're talking about the restricted application, file and suspend, pretty much nonstop here. Some of the folks out there may not understand those options at all. Let's quickly just explain how these options work before we talk about the other strategies. So let's talk about file and suspend. That's when I file an application for benefits, but I suspend them. Under prior law, by doing so, my spouse would be able to collect a spousal benefit off me while I'm earning those delayed retirement credits, 32% more when I'm age 70. So at age 66, I would file and suspend to allow my wife to collect a spousal benefit off me. The restricted application is different. That allows me to collect a spousal benefit off my wife, leaving my own benefits untouched and earning those delayed retirement credits. So the file and suspend allows my wife to collect off me, and the restricted application allows me to collect off my wife. Both those options together represent the second leg in our three-legged stool, the coordination of spousal benefits. And it's really how advisors can bring more value to the table by being able to sit down with your clients and talk about these options. There's still pockets of folks that can use both of these options. You need to understand at what age those folks need to be currently to be able to use those options. So the restricted application, I'm claiming a spousal off my wife. File and suspend, my wife is claiming a spousal benefit off me. I just thought, Jim, we should cover that just briefly so they kind of know a little more about what those options really mean.
Sure.
Hey, Jim, let's go down to the bottom two bullet points. A lot of advisors think that the new laws take away delayed retirement credits. That's not the case. You still get 8% more per year. So if you wait to age 70 and your full retirement age is 66, your benefit has gone up 32% from $2,000, if it is $2,000, to $2,640. And by that nature, if the husband is the higher income person and he's generally going to pass away earlier, if he waits age 70 and maximizes his DRCs, now we're also maximizing the surviving spouse benefit. So those two strategies are still tried and true and still exist. Husband quit to age 70, maximize his DRCs, gets 32% more, thereby leaving more money to his wife upon his passing. And of course, if you're going to be 62 by the end of this year, or officially, Jim, 62 by January 1st of 2016, you can go ahead and file a restricted application anywhere between now and age 69 and 11 months.
Well, between full retirement age and 69 and 11 months. Not now. If you're going to be 62 now, you're still going to have to wait 4 years to file that restricted application.
Okay, I misspoke, but because I get that question all the time.
I know.
Yeah, you can't. Yeah,
that's the important. Claim and suspend. You cannot file the restricted application until you have reached your full retirement age. So people that are 62 now can't file and suspend. It's just the folks that are reaching full retirement age. And one question we do get too, well, if I don't file and suspend, will I still earn the delayed retirement credits? Kind of where I think some of these folks are coming from. And that has nothing to do with that. If you don't take a benefit, whether you do nothing or you file and suspend, you still earn the delayed retirement credits. The advantage of the file and suspend was, as you said, it allowed your spouse and any children to come along and take their benefit.
Some other strategies. The top one here. Maybe the higher income earner, let's assume it's the husband, should consider taking his benefits maybe at let's say prior to age 70 to allow a spouse to start collecting a spousal benefit off of his work record. So the general rule would be, under the old law, we'd have the husband wait to age 70 to maximize his DRCs, and then we would then the wife would have maybe done a restricted application at her age 66. But now, since the restricted application is off the board, maybe we may tell the husband to collect at 66 to allow the receiver of a spousal benefit earlier by the spouse. So if I made 66, I can get $2,000 off my work record. My spouse can get $1,000 off me as a spousal benefit. Do I start my benefit at 66 to allow her to collect $1,000 off me, or do I wait until age 70, Jim, whereby at that time now my benefit's gone up 32%? But what's the trade-off? Quickly, right. The trade-off is that she misses 4 years of the spousal benefits, or $48,000.
Right, and I had a perfect example of that with a discussion just this afternoon. The individual's wife has no work under Social Security, so all she's eligible for is spousal benefits. And his plan was he was going to claim and suspend at full retirement age, allow his wife to take her spousal benefit. And now, because he's not going to be full retirement age in time, the claim and suspend is gone for him. And that his thinking is, do I take it at 66 to allow my wife to file? Do I wait until age 70 to increase what I'm going to leave her as if she survives me? And we figured out they were giving up about $180,000 between the two of them from 66 to 70. And with the increase that he was going to receive, she receives no increase. Her benefit was going to be the same. With the increase he received, it would take him about 22 years to recover that just to break even. So he pretty much decided he was going to go ahead and file at 66 and take his benefit. So that first top option there on this page is what they decided to do. That could very well be. It may not be that for everybody. Depends on their ages. Are they eligible for anything on their own? So how much of a spousal benefit will they truly receive? Those kinds of things that we would have to look at.
So Jim, then let's go down to the bottom strategy. Here we have maybe the wife collecting as early as age 62. Husband's going to wait to age 70 to maximize his DRCs, which will in effect then maximize the surviving spouse benefit paid to his wife as a surviving spouse upon his passing. With the husband waiting to age 70, and we know more or less that the wife is going to step into his shoes as a surviving spouse, why not just let the wife collect her benefit at age 62, or some portion of the spousal benefit if it's payable, but if he waits to age 70, it won't be payable. So let the wife collect her benefit reduced for age at age 62, knowing full well down the road she's going to step into his shoes as a widow anyways. Jim, under old law, we would say tell the wife maybe to wait to age 66 because the restricted application might be on the table. If that's not on the table anymore, why wait to 66? Claim at 62, invest the money. Let the husband wait to age 70 and maximize the DRCs.
And it's going to depend on their ages. If she's going to be 62 next year, and for her, none of this applies, the restricted application, none of that. She could just take her benefit. He could file a restricted application. And then that way they have that her income reduced, but he's getting the additional spousal benefit. Now at 70, then he gets the higher benefit. If they were both born long enough ago or short enough time ago where they both turn 62 next year, this could still be an option that they may want to look at. Again, it's all dependent on their ages and their work histories.
Jim, I had a phone call just yesterday. The husband, there is a 10-year age gap, and he's turning age 62, and we talked briefly, and I said, is it important for you to be living, to not to be living, to be living?
That's always important, isn't it?
I don't know, unless you're a Browns fan. Yeah, sorry.
Yeah, after last night, that was just, that was terrible.
I'm a Browns fan, folks, so I can say that.
I felt for you last night.
Okay, let's move on. So anyway, 10-year gap in age. I asked him, is it more important for you to be leaving more money to your wife upon your passing? Because more likely than not, she's going to be collecting as a surviving spouse pretty early in her life and outlive him for 20 or 30 years. So if he takes at 62, he takes the 25% haircut. If he collects at 66, he gets 100% of his benefit. But if he can wait to age 70, now his benefit's gone up 32%. And that increase, Jim, as we know it, is permanent. It doesn't go away. Like the decrease to age 62 is permanent, so is the increase up to age 70. Jim, the second bullet point, can both spouses still wait to age 70?
Oh, absolutely. You can both wait till age 70, and that oddly enough, is still a better option than both of them taking it at age 62 normally, but particularly if they're close in age. But you still have that option. You take folks that do not have claim and suspend and restricted application, either one of them. They still have about 9 options. This is one of them.
And of course, there is still coordination of spousal and children benefits compared with the number holder, the wage earner, the dad, the husband. So, does the husband take benefits at 62 or 66 to allow benefits off his work record to be paid, or does he wait to age 70 and now his benefit has gone up 32%, and then upon his passing, his wife would get more money for the rest of her life? Not only that, Jim, but upon his passing, maybe the child is under 19, and the child would get more money for the rest of his or her life. Would get more money up until age 19.
Right.
Okay.
Or 18 or 19 if they're still in high school.
I didn't want to confuse folks, Jim. Hey, Jim, I have a series of questions I want to ask you.
All right.
I've added a couple. Hope I don't mess you up.
So I have to pay attention.
Yes, you do. We receive questions all day long about the new law. Here's a question. My husband is 69, has been receiving benefits for 3 years. I'm now 65 and will turn 66 in May of 2016. I plan to do a restricted filing at age 66 and receive 50% of my husband's full benefit. Jim, is she grandfathered in?
She is grandfathered in because she's already obviously past 62. She's going to be 66 next year. He's receiving benefits, so the claim and suspend doesn't even come into account, although if he hadn't filed, he could have.
Yeah, claim to suspend.
So,
yeah.
They, in their case, they actually pretty much had all the options available to them.
Next question. Wife is age 63, husband 64. The original plan was for the husband to file and suspend at full retirement age and to file a restricted application. Jim, is this still possible?
Half of it is the husband will not be able to claim and suspend. She would be able to file a restricted application, but only if he files for Social Security benefits and receives those benefits. So he'll have to apply, and then she could do the restricted application. Otherwise, the restricted application is not available to her.
So if your clients were considering this or a similar strategy, you need to reach out to them, because the strategy as it is just doesn't work anymore, and they need to revise their thinking. Next question. Husband is 65 and 7 months. Wife is 62. Should he consider the file and suspend strategy? Should she file a restricted application at her full retirement age?
Well, they certainly want to consider those options. he can claim, or he can file and suspend. That's not an issue as long as he actually does that before the 1st of May of next year. And then even though she's just now 62, in 4 years, when she reaches full retirement age, that's going to be an option available to her, is to do the restricted application.
Jim, would your answer be different if he was 4 months younger, 65 and 3 months?
It would. What it means is he no longer has the ability to do the claim and suspend. So she still has the restricted application option, but only if he actually takes his benefit. And in her case, what that could be, since they're about 3 years apart, maybe that means, and we just want to look at it, doesn't mean they should do this, but she would want to consider waiting till 67 when he reaches age 70, and then he could take his benefit at 70, no reason to wait, and she could go ahead and do the restricted application. So it's still an option that we would look at.
I have a client, and she is 66 right now, has not filed anything, and the husband is 65 and will be 66 in September. My understanding is that she can still file and suspend, and he in September of next year can file off of hers until he's 70. Yes or no?
That is correct.
And let's break this down. Let's determine why it's correct. She wants to file and suspend. She can do that because she's age 66 currently.
Yes.
He wants to do a restricted application. He can do that because he's over 62 now.
Right.
So she does the file and suspend. She does, and then him in September 2016 will file a restricted to claim a spousal off her. So he will continue to earn those delayed retirement credits for 4 years.
Yes.
Up until age 70, September 2020. Okay, Jim. Do any of these changes affect surviving spouses?
No, the deemed filing has never applied to surviving spouses. They've always had the opportunity. Of course, at age 60, you can't apply on your own. You have to be 62 or older, but you can apply for widows or widowers benefits as early as age 60, even as early as age 50 if you're disabled. But normally it's age 60. Then you can apply on your own at 62 or full retirement age or 70 or anywhere in between, or you could take your own at 62 and take the survivor benefit at full retirement age. They've always had those options. They're going to continue to have those options.
Jim, every day I get a question about our next topic, divorced spouses. Do these provisions affect benefits to a divorced spouse?
Well, they can. It depends on how long they've been divorced. There's two categories of divorced spouses. There is the regular divorced spouse. They have to be single. They have to be 62 or older, married to their ex-spouse 10 years or more. And then the next requirement is that the ex that they're filing off of has filed an application and is receiving a Social Security benefit. Can be retirement, can be disability, could in the past even be the file and suspend. But in that case, then you could apply for the benefits. But if you've been divorced then less than 2 years, if your spouse didn't apply, you couldn't apply on your ex-spouse. You couldn't apply on their record, which brings us to that second category of divorced spouses, which says, in this case, now both of you must be age 62 or older. You're still single. You were still married to them for 10 years or more, and you've been divorced to them for more than 2 years. Now, this is where the independent comes in, the independently entitled divorced spouse. You can file for benefits whether they've applied or not. So independently of them filing for benefits, you can file for and receive your benefits. So under the first category, these rules could apply. If somebody's receiving benefits or ex is getting a check, they've been divorced 6 months, and now the ex says, well, I'm going to suspend my benefits and earn some delayed retirement credit. It's going to suspend his ex-wife's benefits as well. And then, though, if they've been divorced for more than 2 years, then that converts her to the independently entitled divorced spouse, and she would continue to receive her benefits.
Great. Jim, let's talk about our three-legged stool. We've done about 1,200 consultations since 2010. And for married couples, it seems like the top 3 to 4 options always have these strategies included. So we put together a three-legged stool to show a married couple how they can maximize their benefits. The first and the third legs are still very solid. It's the second leg, Jim, that has a little wobble to it. So the first leg is at least one spouse will wait to age 70 to maximize their delayed retirement credits. Generally, that's going to be the husband. He was a higher wage earner, and plus he's going to pass away earlier. We're going to usually have the husband wait to age 70. Leg number one leads us right into leg number three, maximizing surviving spouse benefits. So if he waits to age 70 under leg number one, under leg number three upon his passing, she gets more money for the rest of her life too. Jim, you always say about 75% of the folks know how that they can get more money by waiting to age 70. 50% of the folks understand how and why to maximize surviving spouse benefits. But it's that second leg on the three-legged stool, being able to still coordinate the wage earner with spousal and or kids benefits. That's really where the value is that advisors can still bring to the table by talking about leg number two. So, Jim, what do we mean by leg number two?
Well, you're still coordinating spousal benefits, meaning you just don't say, "Oh, it's time for me to apply," and you go apply, and your spouse says, "Yeah, it's time for me to apply," and they go apply. You want to look at the various options, what it means. Well, if I take mine at 62 and I'm the higher earner, then my spouse is going to receive less if they survive me. And in the meantime, how much is our income going to be each month from Social Security? What part of the money I need to live on for each month is going to be part of Social Security? And by coordinating benefits with my spouse, and when I take it, when my spouse takes their benefits, then you can maximize still the income coming into your household.
So this three-legged still very much works, but the second leg is a little different. The kind of the big guys that we relied on earlier, the file and suspend and the restricted application, are being phased out. And if you're under 62 currently, by the end of the year, you can't use either of those options anyways. So we have to rethink leg number two. There are only certain pockets of folks currently that can still use those options. It being 62 by the end of this year, restricted application, turning 66 by April of next year, April 30th, you could do the file and suspend. For everyone else, the second leg and the three-legged stool needs to be examined, needs to be re-looked at. It's just not as simple as saying husband files and suspends, the wife does the restricted, or vice versa. It takes a little more creative planning now. Folks still have options, and if they don't explore their options, they're not going to make a proper decision. And I don't want any advisor that's on this call today to think that planning is gone for Social Security. It's not gone. People still have, we used to say 10 to 15 options, right, Jim? Now we might say 7 to 12.
Well, minimum of 9.
Minimum 9, 9 to 12, 9 to 13. So folks have fewer options, there's no doubt. But they still have options that they need help with. They need to understand their benefits. They need to find a way to maximize their benefits. So advisors still need to harp on, incorporate the second leg and three-legged stool into their client's plan to get more money out of the system. Jim, thinking inside the box is what lots of folks can do. You look at benefits at 62, 66, and 70. You need to incorporate leg number two, the coordination of spousal benefits still, just in a different way. Otherwise, you're just thinking inside the box. And Jim, anybody can think inside the box.
Yeah, and that's a pretty good guarantee to get you less money.
Pretty good guarantee. It's almost a guarantee, a certain guarantee. Oh, hey, Jim. Hey, Jim, let's talk about changes in Medicare. Oh, for folks that were going to be new to Medicare and Social Security in 2016, they were going to see a 52% increase in the Medicare Part B premium, going up from $104.90 up to a whopping $160 a month. Congress, though, Jim, found a way around that. Can you imagine? They found a way around that. Congress realizes that the medical expenses are still going to be there. So, without any issue with the credit rating of the U.S. government, credit score, that they're taking out a $7.5 billion loan to pay for these additional Medicare costs. $7.5 billion loan. That's a creative way of coming up with this, with the money to pay the Medicare costs. And this way, Jim, they were able to hold down the premium increase to just $118 a month for the baseline folks. Folks that, Jim, was it earning less than 170? Is that the AGI figure I'm looking for?
Right, for a couple under 170.
Okay, you're going to pay 118. But not only will you pay the 118, Jim, but you're going to pay a $3 surcharge to pay down the debt. So beginning in 2017, Jim, every Medicare beneficiary will pay the additional $3. For now, it's folks that are new to the Medicare payroll, Medicare rolls, and also those folks that were not on Social Security in the past. When you combine the two, if you were lacking one, then you would be paying the $3 surcharge, and you have this additional premium to pay.
Right.
Now that confused everybody.
Well,
but
if you're receiving a Social Security benefit check, you won't see an increase in your premium.
That's the key.
If you if you're getting Medicare only, or you're paying more because you're over that 170 threshold, or you just newly apply, you turn 65 next year, you'll pay the 118.40 plus $3. So really, because it's 118.40, the government doesn't say this, but it really in effect knocks it up to 119.
Jim, yeah, you have a way with words. Thank you for bailing me out. Okay, so the problem is a little-known provision called hold harmless. If you're receiving a Social Security benefit and also enrolled in Medicare, then your Social Security benefit cannot go down due to an increase in Medicare. And with no COLA adjustment expected in January of 2016, that means that people currently on Social Security and Medicare cannot see an increase in their premium. So, Jim, everybody else is going to see an increase in their Medicare premium, and they have to take up the slack. So Congress felt like, hey, let's take some money out and take a loan off from the federal government, better than them taking a loan off from Chinese folks. Anyway,
well, that's where they get the money from.
Social Security Disability Trust Fund. It was due to become depleted by the fourth quarter 2016. Congress came up with a way to extend the solvency by 6 more years to 2022. Of the 6.2% that is taken off of FICA taxes, under the old law, 1.8% of that went to the Social Security Disability Trust Fund. But now the Disability Trust Fund is getting more money. Instead of 1.8%, now they get 2.3%. That increase in the allocation of funds to the Social Security Disability Trust Fund will apply to wages paid in 2016, 2017, and 2018. So, Jim, this is the first time we've reallocated payroll taxes, right?
No, it's not the first time. They've done it in the past. Maybe if in whenever it was, 2011 and 2012, or 2010 and 2011, when they reduced the payroll tax by 2%, they could have left it alone and put 2% more in the disability fund. But that's thinking ahead. So why would you want to do that? But yeah, they've done this before. In the past, they were always able to replace that money back into the retirement trust fund. Whether this happens again this time remains to be seen. If the economy takes off and we start booming again, then that could very well happen. We'll just have to wait and see.
Okay, Brendan, we are ready for advisor questions.
Well, thank you so much. We have a lot of questions, so we'll get started and go right through them. The first question: I am 67 years old, FRA, but do not plan on taking Social Security until 70. My spouse will be 66 on May 9th, 2016. Can I still file and suspend my benefits, but have my spouse start the spousal benefit for May of 2016?
Yes, you can definitely do that. Just make sure that you do the file and suspend in advance. You want to do it right away. You definitely want to do it before May. That puts you into place under the old law. Your spouse, being that she's 62, obviously, before next year, can then do the restricted application effective with May.
Next question, please.
Our questioner follows up and says, I understand you can file for benefits up to 3 months ahead of time, and it sounds like he's correct on that.
That is correct. You don't have to, but it's a good idea to do that. If you want to get your benefits on time, it's a good idea to apply in advance.
Well, Jim, let's spend 15, 20 seconds on how do you apply for benefits, since this person brought it up anyways. Our preferred way of applying for benefits is to apply online. You go to ssa.gov and you find the lady in the blue sweater and you apply for retirement benefits. And that's because many times when you go down, if you go down to Social Security to apply, you may be told you can't do what you want to do, even though you may have in front of you a detailed plan. Many reps at the Social Security Administration don't understand what a file and suspend or restrict application strategy can do for you, and may tell you those options don't even exist. So we tell all of our clients to file online. However, Jim knows very well that is not at all an intuitive process. If you want, you can do both file and suspend and the restricted application online, but more likely than not, folks really won't understand how to answer the questions to do either one. Am I right, Jim?
Yeah, there's not questions that specifically lead you through it, but it is possible to do it online.
It is. But we suggest folks go online to apply for benefits, because if you go down to the local office, it's likely that you're going to be told you can't do what you want to do, and nobody likes to hear that. Next one, Brendan.
We have a question about the spousal election. You had to be 62 by the end of this year in order to qualify. Does that mean your spouse has to have filed and/or filed and suspended by May 2016 to qualify, or any time they file you're eligible?
Well, for the spouse to apply, I guess I'm a little confused what it is exactly they're looking for. Spousal benefits are payable from someone's record when they have applied for benefits. So your spouse applies, then you can be technically eligible, but you're eligible as early as age 62 to take those benefits regardless of when your spouse applies. So if you're 62 and your spouse is 66, they can take their benefits or they can claim and suspend. You can file just regular spousal benefits, or if they're 62 now, in 4 years they could do the restricted application.
Tim, let me interject if you don't mind.
Sure.
I think, though, the question is a little more that, let's say the wife is age 62 now, so she can do the restricted application down the road at 66, but in order for her to collect the spousal benefit at 66, the husband either needs to have turned his benefits on, or he could have done the file and suspend if he turned 66 by April 30th of next year. I think that was the direction of the question, Brendan, but really I'm not 100% positive.
I think so too. Christine, thanks for the question. If you have a follow-up question, please go ahead and send it in. The next question, when spouse number one files early, before FRA, does it also reduce her future spousal benefit by the same percentage?
No, the spousal benefit is reduced based on their age when they file that application. So if you file on your own at 62 and don't become eligible for the additional spousal benefit until you're 66, the spousal portion will be unreduced. But you still don't get 50% of your spouse's benefit because of the way it's computed. I mean, you took your own benefit early. That portion is still reduced, but the spousal portion, they're each based on your age when you take those benefits.
So let me add to that too. Let's assume my full retirement age benefit is $2,000. Let's also assume I want to take that early at age 62. So now it's reduced down to $1,500. My wife is at age 66. She wants to collect the spousal benefit off me. She would be able to collect the full $1,000 because she's at her full retirement age. If she wants to take that spousal benefit at her age 62, then it would be further reduced by 30%. So the spousal benefit is only reduced if the spouse looking to collect that spousal benefit is under their own full retirement age. Next question, unless we're confusing people.
Oh no, we're on a roll here. A person born August 1, 1951, files and suspends in March of 2016. Will his spouse be able to claim a spousal benefit if the 8/1/1951 person does not take his right away?
Yeah, if they claim and suspend, that allows the spouse to take the spousal benefit when either as early as age 62. If they're not eligible for any on their own, they could just take the regular spousal benefit reduced at 62, or in this example, they could even wait till full retirement age and still do the restricted application. But even though there's about 4 years apart in those actions, say the husband files now and the wife applies 4 years from now, they're still under they still have that available where he can claim and suspend, she can do a restricted.
Next question, please.
Okay, our next question. I am 69 and have taken benefits since 66. My wife is 64 and she has not taken any. If she were to take half of mine now, and when she turns 66, her benefit will be higher than half of mine, should we do that or just wait?
Well, if she applies now because she's not full retirement age, that's where this deemed filing is going to apply. She would have to take her own first. So you just don't have a choice. And then if there's a spousal benefit boost, she could get that. But she can't just take the spousal benefit at 64. She could, however, wait until her full retirement age and just take the spousal benefit, and then somewhere no later than age 70 switch to her own and get the delayed retirement credit.
So in other words, in this situation, she can wait till her age 66, do the restricted application, and then wait to age 70 and earn those delayed retirement credits.
Okay, the next question. What happens to people at 62 who retire at 60 with a pension and early Social Security paid to them by their company or the federal government after the 2-year period? Can you explain how this works?
Well, yeah, basically what those folks are doing is they're receiving a supplement to their pension because they retired before they were old enough to receive Social Security benefits. So what they receive is what the company determines they would receive in Social or will receive in Social Security benefits when they reach 62, and they give them that supplement until they reach age 62, and then it stops, whether they apply for benefits or not. So one of two things happens: either they come in, they apply for their Social Security benefit to cover what the company no longer pays them, or they would have, if they wanted to increase their Social Security by waiting, they actually just do with less money until they apply for Social Security. So pretty much it forces people to apply at 62 because most of the time they've become used to that income and they need to replace that now that it's stopped. And it's the same with the federal government under the new Federal Employees Retirement System. They do that as well. They will pay you a supplement until you reach 62, and then that supplement ends because now Medicare or because Social Security can kick in.
In the case of a married couple, do both parties need to be 62 this year in order to file a restricted application?
No. I mean, if one is 62 this year and the other is 62 next year, then the one that's 62 this year has the ability to file the restricted application. The one next year doesn't. What would happen is the one that turns 62 this year at their full retirement age would still have to wait until their spouse filed for Social Security benefits. If they had already gone ahead and applied, then at full retirement age they could do that. So it's independently based on the date of birth of each individual.
And let me also add, even under the prior law, husband and wife cannot both file a restricted application to claim a spousal benefit off the other spouse. So there's no change there. And that's because in order to be collecting a spousal benefit, the other spouse needs to turn their benefit on or haven't done their file and suspend. So husband and wife cannot both file a restricted application either under the old law or under the new laws. But one can.
And we are running out of time. We have time for just 3 more quick questions. And Mark and Jim, would you mind if I send you the questions that you didn't have time to answer today? Would you be all right with that?
Yeah, that's fine. Go ahead and send that to us.
Right.
We'll answer. If you want to send us all, even the ones we answered, we'll just, if you want to hand them out to everybody, that's fine. Just send us a list of questions. We'll throw the answers on there and ship them back to you.
I let Jim answer that question because he's going to be the one to answer them.
All right. Case, no. Yeah, no, I'm just kidding.
Thanks, guys. We've just got a few more that we have time for. If spouse number 1, currently age 62, claims her own benefit early, does it reduce the restricted spousal benefit available at age 66 to her husband, who is also now 62 when he turns 66?
No, that when the number holder takes their benefits doesn't affect the spousal benefit. So Mark kind of gave the example before. If your full retirement age benefit is 2,000 and you take your benefit at 62, you get 1,500. But your spouse's benefit is still based on half of that 2,000. So that even though you're just getting 1,500, your spouse could end up, at their full retirement age, get the full $1,000.
Okay, we've got a last question and then one more on deck. Wife is 63, husband is 56, and they have a 16-year-old son. Should she do something now so they can get a check for the 16-year-old now?
Definitely something that they would want to consider. Of course, it depends. Is she working? Her earnings are going to affect the ability for both her and the child to draw benefits. But, you know, that's something that you would want to take into account. If she's not working, then I would say you definitely want to look into that. Is she the higher earner? Is the husband the higher earner? If she's not the higher earner, it may not hurt them all that bad for her to take the lower, reduce the benefit anyhow. But that's definitely something they'd want to look into because that not only is she giving up her benefit by waiting, but she's giving up the child's benefit as well.
And my wife, age 66, has some zeros in income history. Is there any advantage to filing 2015 taxes prior to file and suspend?
Well, it's particularly not file and suspend. You're not really concerned with what the benefit amount's going to be at that point. The computation of benefits is not locked in when you apply for benefits. As earnings are added to your earnings record, then you will see an increase. Even if someone's receiving Social Security, if they continue to work and earnings show up on their earnings record, so in 2016, when 2015 starts showing up, Social Security is going to go back and look and say to see, can we replace the lowest year used in the computation of your benefit, and particularly if it's a 0 year, it definitely would. So they'll get that increase anyway.
And we're going to sneak in one last bonus question. Could any of these strategies apply to a widow?
There are strategies that apply to a widow, not restricted application or claim and suspend, but a widow they still look at their own benefit versus the survivor benefit. And they can take, say, the survivor benefit at 60 and look and even delay their own benefit to as long as age 70, and they'll earn those delayed retirement credits. They can take their own at 62 and the survivor at full retirement age. So they definitely have options, and their options actually are still the same. Those didn't change at all.
That's about all the time we have. I want to thank both of our outstanding presenters for this very informative presentation and timely. And also want to thank all of our participants. And I want to remind you also to access today's presentation, please use the web link that will be provided in the automated follow-up email that you'll be receiving on Thursday, December 3rd. That'll have a web link that will enable you to access today's recorded webinar. Thanks again, and this concludes the NAIFA webinar.
Thank you so much.